This is Michael Popok. Don't check your dial. Don't check your watch. It's time for Legal AF After Dark. Donald Trump, when he's not trying to delay the inevitable, which is his jury trials and his criminal cases and his civil cases, he's trying to use the immunity decision that his MAGA right-wing Supreme Court gave him back on July 1st in all of his other cases. Everything to Donald Trump is immunity. Everything is immune. Whatever he did, whether he was president or not, it's immune. I got a parking ticket. Immune. I got a speeding ticket. Immune. I committed fraud. Immune. Is it? Well, the Manhattan DA's office just filed their papers against the attempt to use the immunity defense in the 34-count felony conviction for Donald Trump when he wasn't even president yet, but when he was busy covering up the Stormy Daniels sex act and paying her off through Michael Cohen. We break it all down the only way we know how, uncensored, unfiltered, unplugged, sometimes unhinged, on Legal AF. Take a listen.
The Manhattan District Attorney criminal trial. Trump was convicted on 34 felony counts of falsification of business records. Donald Trump trying to throw out the verdict against him by a jury of his peers that found unanimously that he was guilty 34 times over. Trump argues that his buddies on the Supreme Court, those right-wing extremists who gave him absolute immunity and also evidentiary immunity from information when he was in the White House being introduced at trial, if it involves official conduct, that should have been excluded. So Trump's main argument here is not that the underlying criminal conduct of the falsification of business records is subject to the immunity. Trump's argument is the prosecution introduced a lot of evidence of things I did while I was in the White House. That's official conduct. You now have to dismiss the case. The district attorney's office did an incredible job, and I think they navigated that Supreme Court order. Popok, tell us what they did, and then I'll let you. Then I think you take the pivot thereafter as well to the 11th Circuit briefing schedule. Sure. Not that much to discuss there, but also I think it's going to show that Judge Eileen Cannon's days, I think, are numbered as her being the judge. Popok.
Agree with that. She doubled down on a losing hand. We'll talk about that next. In New York, I really appreciate it. I read, you and I and Karen all read the 64 pages that came out by the Manhattan DA, and another credit to you. I mean, we often credit each other when we are right about things. Our crystal balls are right about things. And you said right after July 1st, the immunity decision came out by the United States Supreme Court that within moments they were going to try to file and use that to vacate or overturn the 34-count felony conviction against Donald Trump, which was done by 12 New Yorkers, fair and impartial jury in state court. And we were all, I agreed with you that they were going to try it. Now, having seen it, it was always a weaker motion than even I thought that they were going to come up with. And Manhattan DA has taken them to task. Their argument, just to be clear, is not that this is Trump's argument, is not that the Stormy Daniels hush money sex act cover up election interference thing was an official immune conduct by Donald Trump, core conduct or absolute immune conduct or official conduct. It's not that. They can't argue that because the whole Trump Tower conspiracy, as the Manhattan DA called it, between Trump, David Pecker, the National Enquirer, and Michael Cohen, then supported and facilitated by others in the Trump organization, like the accountant and the auditor and the controller and all of the money men, all of that. That was all before the election against Hillary Clinton. This was all September, October, maybe November of 2016 before the election, but certainly not after January's inauguration of that year, of the following year. And so how could any of that and the cover-up and the hush money and the payments be immune? So their argument, even Donald Trump did not argue that. Donald Trump's argument is, well, we're not arguing that the conduct's immune. We're arguing that there were certain pieces of evidence that were presented to the jury that under the immunity decision's kind of alternate theory could not be used against, which again, I'm going to tell you this is wrong, but I'm telling you their argument. Their argument is that there was official conduct of the President Trump, that was presented to the jury, which is against the decision of the immunity decision, in which official conduct cannot be used to prove a conviction. Okay, first of all, that's an upside down reading of the immunity decision. The immunity decision said is you can't use official conduct as evidence to try to prove the unofficial conduct to prosecute. That's not what's going on here. The conviction already happened. This is now whether the evidence pieces, which are really just three. It's Madeleine Westerhout, who was like the scheduler in the White House for Donald Trump and helped determine the swing of the revolving door in front of his office, who got in and who got out and when. And the couple of times that Michael Cohen visited, and a couple of times that personal checks for Donald Trump got delivered to him and then signed to get paid off to pay off Michael Cohen about this very private, non-official conduct affair. That was her testimony. Some stray testimony about that Hope Hicks gave when she was the White House communications director and before when she was press secretary about Michael Cohen, but Michael Cohen already testified, so there you have that. And in like a Federal Election Commission form. It's like three straight pieces of evidence over a 6-7 week trial in which there were hundreds and hundreds of hours of live testimony and dozens and dozens and dozens of pages of exhibits presented to the jury. So the argument, which was masterful by the Manhattan DA's office, started with, you effed up Donald Trump and your legal team because you did not preserve this issue appropriately on appeal. You did not object to this evidence as it was being brought in to allow the trial judge to handle it, and therefore you have waived and you have not properly preserved on appeal any of your immunity argument. And they point to, as we predicted, and Karen actually talked about a month or two ago on Legal AF with me, that and reminded us that, there was that huge hearing a summer ago, God, it seems like a lifetime ago, that we reported on from our various vacation locations, in which the senior status judge handling a motion to remove the case from state to federal court, which is what Donald Trump wanted to do, evaluated all of the conduct and said it's not under color of the federal office. This is a private affair and private matters, and I don't want to hear about immunity. And they never appealed or properly perfected that appeal to the Second Circuit Court of Appeals. And so the issue of immunity right there should have been raised, wasn't perfected, and they can't raise it now. And that's the argument, the first argument that Alvin Bragg's office has raised. And Donald Trump knows how to go to the Second Circuit because they ran to the Second Circuit late with Alina Habba on the E. Jean Carroll case and didn't properly preserve immunity and supremacy clause issues then. So he knows how to get to the appellate court. He just didn't do it. And in trial, when Madeleine Westerhout, who took the stand, and Hope Hicks took the stand, they made some limited objections, but none on executive privilege, none on immunity. Now, one of their arguments was, well, how can we make the immunity argument? The Supreme Court hadn't ruled in our favor yet. But the Court of Appeals in New York, the highest court, about the gun decision, the New York versus Bruin decision, which expanded Second Amendment rights, said you need to anticipate these things, especially when they're on the docket and they've been litigated, and you've got to preserve issues that you knew or should have known were going to be that the law could change. You have to anticipate a possible change in the law, and you have to preserve it. You didn't do that. That's first major argument. Second major argument is it's harmless error, which means Donald Trump would have to have shown in his briefing, which he did not, that but for the Westerhout testimony and the Hope Hicks testimony and that one piece of form from the Federal Election Commission and some testimony by Michael Cohen, the jury would not have convicted. And he cannot prove that because there was overwhelming amount of evidence. So it's not this quote unquote error of letting in this quote unquote official conduct testimony is not outcome determinative. The jury ruled with or without that evidence that Donald Trump was guilty of 34 felony counts. That's the argument. And then lastly, they remind the court of the proper reading of the immunity decision, which is that this is not core presidential conduct. Paying off with private checks, a private affair, just because it happened in the White House does not render that core presidential conduct that enjoys absolute immunity. It's not official conduct stretched to its outer perimeter that enjoys a presumption of immunity. It's the other thing. It's the private, unofficial conduct that gets no immunity. This one more brief from Donald Trump will come in. You and I and others will do hot takes on it. That'll be sometime in August. And then Judge Merchan, who's waiting patiently, but I'm sure has already written his opinion, is going to rule against Donald Trump. He's not going to overturn the will of the 12-person jury. Donald Trump's then got to go back, or here we go again, back to the First Department Appellate Division, same court as Engoron, to get a ruling there. He'll lose there. Then the Court of Appeals. And then if he doesn't like the Court of Appeals sometime in 2025, he's going to have to go over and try to take a special writ to the United States Supreme Court, which I don't think is going to work. What does that all mean from all these different timetables that you and I have been talking about on this show? The sentencing is scheduled, I think, for the 9th or so of September on these 34 counts. However, if the appeal is still ongoing, I'm pretty sure Merchan is going to postpone, just to manage expectations here, is going to postpone the sentencing until the appeal is fully exhausted. So we may not get, and I want to just manage, I don't think we're going to get a sentenced Donald Trump before the November 5th election, given the timetables of these various appeals. But we will one day. And if he loses in November, as we expect, he's just going to be citizen, non-candidate Trump standing before Judge Merchan, having lost 34 counts of a felony in New York, right, with his other track record, being sentenced.
So Michael Popak, there we have. So just everyone follows the kind of order of this episode. First, we talked about the intersection of law and politics and how with the momentum, energy, a lot of what I think Trump and their legal plan was informed by Trump basically taking over as a dictator, right? And now those legal plans, are backfiring. Trump lost his recusal request in New York. The wheels continue there. The wheels of justice continue there. Now the Manhattan District Attorney, smart, sharp lawyers who didn't panic after the Supreme Court's decision, they found a way around the absolute immunity ruling that you and I think feel confident that Trump is going to get sentenced in September. I mean, I think Trump,
You think September? I just said not September. You think September?
Well, I think that, I think that the sentencing stays. I think that Judge Merchan I think ultimately he'll
he sentences, but he stays it.
Correct.
Okay, I'll go with that. I'll put.
We're saying the same thing.
I'll put a bet on both red and black. I think he either delays it to let the appeal go by, or he sentences and stays it. I agree.
Yeah, I don't think that there will be an actual prison sentence served pre-election, but I think it will go through the appeals process.
Welcome back. We do that show. We call it Legal AF. We sit at the intersection of law and politics, and we do it the way practicing lawyers who know what they're talking about like to do it. We don't blow smoke. We don't blow sunshine. On Wednesdays, I do the show with Karen Freeman at Knifilo. Saturdays with Ben Mycelis. And then on hot takes like this one, about every hour on the MeidasTouch network. Help them get to 3 million free subscribers. So until my next hot take, until my next Legal AF, this is Michael Popak reporting. Heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know, and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.